Good evening, everyone. My name is Daniel Elumba. It's my pleasure to welcome you to this interview tonight. The theme of this interview is Attacks on Nigerian Judiciary, is it unwarranted and reckless? And our guest is no other person than Professor Chidi Odinkalu. I don't know whether Chidi Odinkalu needs introduction to those who are watching developments in Nigeria. The former chairman of Nigeria Human Rights Commission. He's been running very good commentary on the developments on Nigerian judiciary over the years, especially this year. And if you are among the Nigerian Twitterati, there was one audio that went viral some weeks ago where he so eloquently analyzed the problem with Nigerian judiciary as not starting in 2023. So let me ask from that, Professor Odinkalu. I'm sure you're aware of the audio I'm talking about that went viral. What you said there is very scary. In fact, when it was posted in one of our legal forum, the guy who shared it gave it this byline: the dark clouds are gathering. So are the dark clouds gathering over the Nigerian judiciary?
Well, I don't know. I really don't know. I'm not into the Babalawo profession. But the situation is obviously not very good. And it's not because I say so. If you go back to about 20 years now, effectively, since Victor Waifo retired in 2004, we've had a succession of retiring justices of the Supreme Court acknowledge quite publicly the deterioration of the Nigerian judiciary. After him, Justice Ogebe, when he retired in 2010, was also not particularly pleasant about the goings on there. Justice Ejembieko, at his valediction 2 years ago, was also very unsparing. Coincidentally, Ejembieko and Justice Ogebe, both from Benue State. And of course, the latest being Justice Musa Datijo. These are all justices of the Supreme Court. If you go down the ladder, if you were to read the valedictory remarks, for instance, of Justice Alaba Ajile of the Kogi State High Court, which took place February this year, he was brutal about the state of our Nigerian judiciary, from judgments to appointments to discipline to management of budgets to you name it. So the only thing that outsiders like us, like me, can do is amplify the points they make with a little more vehemence or a little more less constraint than judicial collegiality imposes upon them. But even at that, all of these are very senior judges on whom there was no blemish, no career blemish. So unquestionably, things are quite bad. And then with the 2023 elections, what we have is unprecedented in terms of the judicial folly and chicanery that's been perpetrated across the board. And I think that's really what has led to this present cascade of concern that you're seeing.
What you've just said, I went through the Nigerian law school and the legal system. What is sad to some people of my generation, I'll say my generation because we are getting old now, the products from Nigerian judiciary used to be well respected would be an understatement. We have Nigeria exporting judges to several African countries, Uganda, Gambia, and other countries. We remember judges like Justice Udo Udoma. And then you talk of Kayode, and of course, Oguta. Sorry, what do I say?
Oputa.
Justice Oputa. And when you look at that caliber of judges and you look at what we have now, some people will ask what really went wrong. So what went wrong in your opinion?
But it's very interesting, the examples you gave. So let's go through those. Dodoma received a PhD from Trinity College in Dublin and Oxford University in 1948, I believe. He was admitted to the bar in 45. Received a PhD from Oxford and Trinity in 48, returned to Nigeria, set up practice, and set up practice in Aba, yes, and made good, became the leading practitioner of his generation, vice president of the Nigerian Bar Association at the point, then the leader of the core movement, that is the Cross River Ogoja River, that's Cross River Ogoja Rivers movement, the state creation movement, and the leader of the coalition on minorities in Nigeria. Became a parliamentarian, elected member of the House of Representatives before independence, attended the constitutional negotiations. It was after he was rigged out of the 1959 elections and he returned to the bar that Tafawa Balewa, who'd known him, worked with Adetokunbo Ademola to persuade him to get to the bench, and he became a judge in 1961. But at that point, he had nothing left to prove. As a matter of fact, in that year, he was going to be made Queen's Counsel. That was 1961. Oputa was another outstanding litigator, private practitioner in Port Harcourt, before being persuaded to join the bench. Kayode Esho was in private practice in Jos before being persuaded by Awolowo to join, and Simeon Adebo to join the public service of the Old Western region, becoming director of public prosecutions in the Western region before becoming a judge of the High Court of the Old Western region, and then justice of the Court of Appeal of the Western region, from where he became from where he went to the Supreme Court. Now, one thing about these three careers is their standards were extraordinarily high of qualification, of legal qualification, and of experience. And they all came from the private bar or had major exposure to the private bar. By contrast, until at the point that Sentus Nweze died, he was one of only two justices of the Supreme Court who had had exposure to the private bar. The rest were civil servants. Okay? They rose from the Attorney General's chambers to the magistracy to the High Court bench and all of that. So becoming a judge and then became a matter of career progression through the civil service. And of course, the civil service is a matter of, having directed to. And that really was not an accident. That re-engineering of the legal profession, of the judiciary in particular, began with the regime of Ibrahim Babangida, and it was very deliberate. And so that, that re-engineering from people who had independence intellectually wired into them and ethically, to people who are used to obeying orders and taking directions or directives and obeying them, was very, very deliberate. What the politicians have done now is to deepen it and to add money to it. That's all. So are we going to be able to go back to that? I don't know. But as long as we keep sourcing judges mostly from the civil service and insisting that being a judge is a career progression rather than a vocational calling, underpinned by certain ethical parameters, then I think we are going to be in serious trouble.
Okay, I will come to the issue of the appointment of judges in a moment. But let me first of all talk about the legal training itself. You see, Nigerian lawyers used to go to just one place, Nigerian Law School in Lagos, Victoria Island. And then our generation, my state was the first to go to Buhari in FCT. And then at that time, there was this debate about decentralizing law school. And then also you can agree that the people who were appointed to lead and manage and teach the law school are of a certain caliber. And then we see Nigerian law school decentralized. That argument that it will water down standards appears to have happened even from the legal training itself, before we even progress to the issue of the appointment of judges?
No, I'm not quite sure about that, because there is only so much the law school can do as a physical institution in 1 year. The law school is, whether it's located in one place or located in different places. I personally think that the idea of the law school as a physical institution has passed its sell-by date. You know, if you go to the United States, for instance, there is no law school. They've got a bar that works, and certification is regulated. There are providers. You do your courses, you take your exams, and the bar kicks in and makes sure that its rules are enforced. But the idea of the law school in Nigeria as a physical location where you send people to spend 1 year and do very little, or rather with the expectation that they're going to re-engineer a process that's really flawed from the law faculties, I think is fundamentally flawed.
Okay.
At this particular point.
Okay, that's fine. Now, you also talked about regulation again before we come to the appointment of judges, where you have written extensively about. In the matter of regulation, is it a matter of concern to you that in Nigeria we have lawyers regulating lawyers? Unlike what you have in the UK, for instance, you have an independent organization, SRA, populated by non-lawyers regulating lawyers.
I totally think so. I think that's really the Council of Legal Education, which is a statutory body under the Legal Practitioners Act, right? The CLE is one of 5 statutory bodies, and it's not just statutory bodies, it's actually a majority of government composition that regulates the legal profession in Nigeria. And you've got the General Bar Council, it's a statutory. You've got the Council of Legal Education. You've got the Legal Practitioners Disciplinary Committee, the Legal Practitioners Privileges Committee, and the body of benchers. Every one of those has an inbuilt government majority. That and these are basically used for patronage, for sitting allowances, and the goal really of setting standards that work for a legal profession that is independent and capable is secondary to the vocation of the CLE. And I do think that's what the problem is. And you then have a situation in which the Council of Legal Education, which is supposed to be a regulator of the delivery of legal education, is also a provider of legal education in the Nigerian law school. And those two roles don't cohere. So fundamentally, this may have been useful when the design was done by Professor L.C. Bigar in 1962. It's no longer viable today. And we've refused to rethink that, following the Foster Sutton report in 61. We refuse to rethink it and adapt it to the contemporary society. And I do think that the fact that it's in arrears is reflected in the way we are carrying on.
Very good. Now, we now come to the issue of the appointment of judges. First of all, for the benefit of our viewers and for the wider public, because we will eventually upload these on multiple channels on the social media. Can you just briefly highlight us on the process of appointment of judges in Nigeria?
I don't think anyone knows what the process of appointment of judges is in Nigeria, to be perfectly honest with you. I think that is part of the issue. So what is the process? Nobody can tell you. The constitution is very clear. For you to qualify to be a justice of the High Court, a judge of the High Court, or customary court of appeal, or the first level of Superior Court of Record, is 10 years post-qualification experience. That's all. For the Court of Appeal, is 12. For the Supreme Court, is 15. Now, the problem now is this, of course. There is no other requirement other than being qualified 10 years post-qualification. So why is the issue? Let me give you an example. The son of the Chief Justice, Olukayode Ariwola Jr., who's just been appointed a judge of the Federal High Court by his dad, presiding over the National Judicial Council in September this year. The young man was admitted to the Nigerian bar in 2011. In 2012, he did his service. Following that, he came to UCL, I believe, and did an LLM for 1 year. At the end of which he returned to Nigeria to work in the law firm of his uncle. And who is his uncle? What do I mean by the law firm of his uncle? He worked in the law firm of Akeredolu and Olujimi. Rotimi Akeredolu is a first cousin to the Chief Justice, right? So he sat down in the law firm of his uncle for 7 years until 2020. In 2020, he headed to the National Judicial Council, where he became his father's essay, basically, right? Sitting around in his father's office, running photocopying and doing errands and shepherding people in and out of his dad's office. Two and a half, the year after that, or less than 2 years after that, his dad becomes Chief Justice. He becomes Major Domo in his dad's office, and that qualifies him to be a judge in 2023. Now, if he were not his father's son, this young man would not even make the first cut of applicants for consideration. But because he's his father's son, he's got ahead and he's headed the list from Oyo State. This is the point, that nobody actually does know. Now, what is supposed to happen, of course, is the NJC is supposed to declare vacancies and announce them. On announcing them, it then requests nominations from different places, from the bar, from judges, and from where it announces them and transmits them to the head of the relevant court. The head of the relevant court, of course, will be a chief judge, whether a state chief judge or a chief judge of the Federal High Court, or president of the Customary Court of Appeal, or a Grand Cadi, or whoever. So that's the first thing. Now, what would happen? There'll be vacancies at the state level. The chief judge would then request, having consulted with the Judicial Service Commission, which the chief judge heads, would request the NJC, would notify the NJC that there are vacancies and request authorization to fill them. The NJC would then, and in that request, the chief judge will say, this is what we've got. We've got court halls, we've got this appropriation to make sure that the judges, when they come in, they will have cars, they will have accommodation, everything is ready. The NJC will look at this requisition and approve and say, okay, so we'll declare 5 vacancies, because you may request 8, but they look at the figures and the numbers and say you don't have enough money. So we'll approve 5 vacancies for you. You go and announce 5 vacancies. The chief judge should then go and tell the bar, we have 5 vacancies, you can apply. The civil service can apply. All of those people can apply. They will take soundings, take vet, and then prepare a short list, and then send out and say, this is the short list. Can we have your comments? On the basis of those comments, they will make their recommendations and send up to the NJC. The NJC will consider and decide whether or not. So the recommendations will come from the State Judicial Service Commission to the NJC. The NJC will look at those, approve or reject. At that point, it is then sent back to the state governor, who will appoint. Ideally, that is what it is. In reality, that hardly ever happens. By the time the bar is notified, the appointments have been done, because the governor would usually transmit names in a red pen and say, these are the people I want. Somebody will come from the governor's aide, another will come from the governor's wife, another will be the governor's mistress or something. All of them will be added. Then a chief will add 1 or 2 of his own for the slot, or her own, and that's it. So because of this, the process is no longer governed or governable. And why is that so? It's lacking in transparency. That is what we've got to address.
Well, what do I say here, actually? So the problem is basically as a result of the fundamental defect in the not Nigerian as a person, but the system character of the system. Because this, what we've just described, is not just happening in the judiciary, it cuts across board, the civil service, the police, the army, all over the place.
And that's the point that S.A. De Smith made consistently, in his writings. If you remember De Smith, who was the authority in constitutional administrative law in England, and also in the constitutions of transitional societies post-colony of the British Empire, which is that judicial independence is secured, really, not by constitutional provisions as such, but by the practice and by the social mores of any society. And in that sense, Nigeria has converted judicial independence into a plaything of politicians, of judicial insiders, of people who are related to those two sets of people, and no more.
Because otherwise, what we have just described about, I've never been able to pronounce his name, the CJN. What you have just described is enough for the system to say, no, this is not acceptable.
But, you know, when Aloma Mukhtar was the Chief Justice, she tried to police this a bit, and I think we've got to give her some credit. You know, there are areas in which I criticize her, of course, but we've got to give her some credit for having been able to withstand a lot of that and face it down and police it in a way that brought some respectability to the process of appointment. And it tells you that leadership is important. And when it fails scandalously. And people forget, Aloma Mukhtar's son, only son, is a lawyer, and the senior one at that. She did not make him senior advocate of Nigeria. She did not make him a judge. She did not make him a contractor of the NJC. She could easily have done that, like quite a few of her predecessors did after Justice Uwais. I mean, after Justice Uwais, the situation crashed. The ethical parameters of judicial administration in Nigeria cratered completely. But
I wanted to ask that question, but I was afraid because I have a lot of questions in my head. I wanted to ask you, okay, at what point do we really say that it was, you mentioned IPB era, for instance, but I remember that I went to law school after IPB. And this, at that point, we always say that the Nigerian law school is the only place where something works in Nigeria. We also say that even in the universities, the law department was seen as, you know, where there is something, you know, still nicely done, still ethical. And that was in 1999. So when can we really say that the situation starts really getting bad?
I mean, the system was the current system of what I call filial and genitalized judicial appointment, I think I trace to the Chief Justiceship of Justice Belgore. Now
Belgore?
you know, yes. Now you cannot say before that. I mean, if you looked from Adetokunbo Ademola, Taslim Elias, Danley Alexander, Fatai Williams, Shode Indesho Emimo, Ayo Erikefe, Mohammed Bello, and Muhammad Lawal Owais, 8 of them. You cannot accuse them of having sought to put their sons and grandchildren and daughters and mistresses to be judges. No. And of that lot, look, Taslim Elias has 3 sons who have PhDs in law, and you know, in very verified areas of law. None of them is a judge in Nigeria. One of them is a senior advocate, and he became senior advocate.
But judges at that time, they never got to earn money because when we were in the law school, we always say that if you are a successful lawyer, you are called to be a judge. Why will you do that if you have a successful law firm?
Now, you see that, so that's the point. Because by and large, they basically, you know, there was an implicit bargain. You had a lot of respect and authority as a lawyer, and for that you did give up some money.
Yes.
Okay. Now, a tremendous respect, and that was because people also expected you to behave properly in a particular way, and many of them, for the most part, comported. They carried themselves with dignity and respectability, and because of that, society gave them a lot of respect and honor. Right now, it's not the case. A judge also wants to be able to send their children to Cambridge and Oxford and pay 60-something, 70-something, $80-something thousand in school fees per annum without the benefit of a family trust fund. And all of that money, of course, you can be sure how it is got, and that's the problem here. Okay? Now, they, as I was saying, when you look back at this, of that 8 that I just named, from Taslim Elias to Justice Uwais, it was only Justice Ademola whose son eventually became a judge. That was Philip Adeneko Ademola, who rose to become a presiding justice of the Court of Appeal and was extraordinarily bright, could easily have made it to the Supreme Court. But he didn't make it to the Supreme Court because there were objections on grounds I don't want to go into here that meant that every time his name came up for possible recruitment to the Supreme Court, he was refused on grounds that were very clear. Today, because of who he was or who he is, if I were to move him to the present tense, Justice Ademola would easily have made it to the Supreme Court. And that tells you how badly the ethical framework for appointment has created since then.
And so what we are saying now is not just a situation where we will say, can we just reform the system? Can we have laws to stop this or that? Can we reform this process of the appointment of judges? Because the entire system appears to have simply collapsed.
I think it's more than just talking about reform in terms of laws. That's not to say there are not some things that should change, because if you look at the Constitution, there is nowhere in the Constitution that there is a requirement of integrity or ethics explicitly stated for appointment as a judge. As long as you are standing at 10 years at the bar, you can be qualified, appointed as a judge, irrespective of the fact that you may or may not have integrity. There are no integrity or substantive requirements for appointment as a judge. And that's where we don't need a constitutional amendment to do this. But it seems to me we do need a law that addresses the standards for eligibility for appointment as a judge, and that requires that there are integrity standards to be met for appointment as a judge, and also for management of that. I also do think you need a law to be able to unbundle the office of the Chief Justice. At the moment, the Chief Justice is a collection, a concatenation of patronage. He is Chief Justice of Nigeria. He is President of the Supreme Court effectively. He is Chairperson of the National Judicial Council, pretty much in executive capacity. He is Chairperson, not pretty much, in executive capacity. He is Chairperson of the National Judicial Institute in executive capacity. He chairs the National Federal Judicial Service Commission in executive capacity. He chairs the Legal Practitioners Disciplinary Committee in executive capacity. He's a member of the National Council of State. All of this, one person, right? Now, as a result of that, and of course, he's he oversees the budgets of the judiciary. As a result of that, the Chief Justice is no longer primus inter pares. The Chief Justice is a principality.
So why is this conversation not happening now, especially where what we have just said was famously highlighted by a retiring justice of the Supreme Court just a few months ago? Why is this conversation not happening to unbundle the office of the Chief Justice of the Federation, to farm out some of these responsibilities to other offices?
You will have to ask the people involved. A few of us have been saying this for God knows how long. I can't get tired of saying it. But when you've got this accretion of power and influence and patronage in one person, it's liable to be abused. And it has been abused methodically by every Chief Justice, going back to the ones to when I said it started. Now, can it be changed? Of course it can be changed. But to change that, you need to amend the Constitution, because the role of the Chief Justice at the Federal Judicial Service Commission and at the NJC is constitutional. So you've got to amend the Constitution for that. The other parts, you don't need to. So you can easily amend the Legal Practitioners Act, the National Judicial Institute Act, to remove those roles from the Chief Justice. But the most important one, it seems to me, is that you've got to separate the roles of the Chief Justice in the Federal Judicial Service Commission and the National Judicial Council. One person, the person who chairs the Federal Judicial Service Commission, cannot also be chairing the National Judicial Council. That really is the core of the problem. And if you ask me, the way to do it is make the Chief Justice the chairperson of the Federal Judicial Service Commission, and make a retired Justice of the Supreme Court or a retired President of the Court of Appeal the chairperson of the National Judicial Council.
Why must it be a lawyer? Why must it be someone from the legal system or judiciary that will chair a regulatory body of the justices?
No, it doesn't mean that you cannot have an inbuilt civilian non-lawyer majority, because at the moment, really, the problem is not who chairs. It is that the Chief Justice owns the National Judicial Council. For me, the joke actually is that if you look at the letters of CJN and NJC, it's the same set of letters, just rearranged, right? And quite literally, it is the same office, slightly rearranged, but occupied by the same person. Now, if you have someone, now, given the nature of Nigerian society at this particular time, it's going to be difficult to get a non-lawyer who is not going to be overly differential to a Chief Justice. But a former Justice of the Supreme Court will by themselves be senior as a judge to the current Chief Justice, although they have not held the office of the Chief Justice. Just by that fact alone, you introduce tension into the relationship. The tension will be dynamic, but there will be a tension. And that tension will be important for ensuring that things work properly. If you then have an inbuilt non-lawyer majority in the National Judicial Council, you'll have enough, in my view, to ensure effective control or significant control of the abuses that are happening at the moment, or the kinds of abuses that we now have.
Thank you very much, our viewers. We have been listening to Professor Chidi Odinkalu, former chairman of the Nigerian Human Rights Commission, tonight, discussing the question, all the attacks coming against the Nigerian judiciary, are they unwarranted or are they warranted? Now, Prof, basically, the issue of the problem in the Nigerian judiciary, in my opinion, has come to a head this year. I think probably because of the fact that this year's Nigerian presidential election stirs so much interest among the youth and among people who are not normally interested in politics. So they keyed in and then saw eventually the judiciary deciding electoral results. So, in your opinion, how does this issue of judges deciding the result of election compatible with democratic practices in a democratic country?
I mean, I've had my say on this for a long time. I think it's offensive. I think it's beyond the pale that judges should be computing numbers and picking and choosing who should be the winner in an election. And mind you, going back as far as the Babalaki Commission report in 1986, up to the Uwais Commission report. Now, Babalaki Commission report made it very explicit that where elections are struck down, the courts should order that the ballot be returned to the people to decide who is the winner. That was explicit. That was a recommendation of the Babalaki Commission report. The Uwais panel in 2008, that was when, 22 years later, recommended that we should be careful about how we indulge in judicial settlement of electoral disputes, that would have the consequence of ruining both the democratic process and the judicial system. And that's exactly where we are. But, you know, I don't think the real issue is what they have done in the presidential elections. You really need to go down ballot to see how dreadful this whole thing has been. If you go to Plateau State, and mind you, in Plateau State, the president of the Court of Appeal comes from Plateau State, actually from the same place as the immediate past governor of Plateau State. In Plateau State, every election has been overturned by justices of the Court of Appeal. Now, it's not just that the president of the Court of Appeal comes from Plateau State, and I emphasize this because it is essential to understanding how the judiciary has been weaponized. It is also that the president of the Court of Appeal is responsible for designating judges of the presidential of the election petition process, and in particular for designating the justices of appeal who sit on appellate panels in the election petitions. So the president of the Court of Appeal designates the justices who sit on appeals in Plateau State, where she comes from. And in that state, every election has been overturned by the Court of Appeal in particular. House of Assembly, every election was changed from the party that won it to APC. The House of Representatives, the same thing. Governorship, the same thing has been done. It's now gone up to the Supreme Court, right? Now, there is something fundamentally offensive about the fact that three judges, will decide to infantilize an entire electorate and tell them that they don't know what they're doing. They're not qualified to decide who governs them. And things will be done according to the will of the president of the Court of Appeal and judges appointed by her. That is a judicial coup. And let me repeat this story. In Mali in 2020, the Constitutional Court did exactly the same thing. Okay? They took 31 seats. Now, there was a hung parliament. The Constitutional Court took 31 seats, won by the opposition, cancelled them, and gave them to the ruling party. That was the trigger for the Malian coup. That was how the uprising started. ECOWAS designated Goodluck Jonathan to go and mediate. They told him to go and sit down in Nigeria. Okay? They insisted on the Constitutional Court being sacked. And after the Constitutional Court was sacked, they said, no, it was no longer, it was too late. The government was overthrown. You don't want that kind of thing. The Malian coup was caused by judicial irresponsibility. And we have got to the situation where the judiciary is goading things in a direction that every Nigerian who cares about democratic government, about government elected by the people, for the people, and by the people, should say enough is enough. This is not on.
What you have just described will cause some minds to really feel repulsed, for want of another words to use. What you have just described in Plateau State. But yet we see, is it the piece of the graveyard that we are witnessing, or that people really doesn't care anymore that these things are happening or taking place?
Well, I think people are, impoverishment has been made the method of government. Most people are hungry. People are looking for food. That's the most basic thing that most Nigerians are looking for now. Today the dollar is exchanging for what, 1,300 and something to the the naira to the dollar is 1,300 and something. And most Nigerians are struggling to be able to eat. And when you're struggling to eat and somebody is inviting you to wrestle with power or overpower, that may not be the first thing that comes to your mind. And I think that's the problem. The government or politicians have found a way to make impoverishment the directive principle of state policy.
Now, so thank you very much for this analysis. We have seen the Nigerian judiciary in a way where some people are saying that the state has not just been captured, the Nigerian judiciary has also been captured, where it appears that the ruling party is using the judiciary to capture political power in areas where they feel they have lost.
Kano is a classic example.
So why are the opposition parties also keeping, if the people are so impoverished to fight back, why are the opposition parties also keeping quiet?
Well, you've got to ask the opposition parties. I'm not one of them.
Because one will imagine that if I'm a party, for instance, and then a party I won Kano State or Plateau State, and I'm seeing, I remember how, when PDP was in power, how ferociously the opposition parties grappled with them. So now that is the other way. Why is the PDP?
You've got to ask them. My own view is, some of them are also caught up in the election petition process, and they're afraid of what they would say and how the judges will treat them and all of that. It doesn't mean I agree with that, because they will still get their comeuppance given the way things are going. I'm just saying.
Okay, well, what about the Nigerian Bar Association then? I think the Nigerian Bar Association should be, I think, the conscience of the judiciary, because yes, that's what it should be. So what's happening there as well?
You've got to go and ask the current president of the Nigerian Bar Association. As you well know, I've resigned from the Electoral Committee of the Nigerian Bar Association on grounds that I made very public. I don't want it to look like I am taking things personal with the current administration of the bar. My views about the current administration of the bar in the public domain, and they're not particularly publishable.
Okay, so now that the people who will regulate judiciary are not functioning. The conscience of the judiciary, the Nigerian Bar Association, are keeping quiet. The opposition parties are also keeping quiet. And we believe that the judiciary should be the last hope of the common man. So where does the common man come into all of this?
No, I personally don't. I think that whole thing about judiciary being the last hope of the common man is
Has been forgotten. It's no longer.
Forgive my turn of phrase. It's totally nonsensical. As I said, as I've written as well, the judiciary in Nigeria has become, depending on how you look at it, it's either the lost hope of the common person, or the last rope with which the common person gets hung. But the judiciary has long ago squandered the trust of the average citizen in Nigeria. And it does not appear to me as if at the highest levels of the judicial ranks, they are too keen to win back the trust of the people. Now, the sad thing, of course, is that many of them then retire from the bench and start to complain that their pensions have not been paid, they are owed their gratuities, they are living in penury, they are living in hardship, they cannot get medical care. And my attitude is very simple. When you were collecting money to decide elections in favor of people whom you knew had lost the elections, you had front-loaded your pension, your gratuity, your well-being on retirement, please give us a break, right? And all of them will retire. I hope all of them do, or most of them do, to live with the consequences of the terrible jurisprudence they are inflicting on the people. Because unless they do, and I wish them a painful old age, because that is the only way people will understand that these kinds of things actually become personal when you are no longer in the system. And I know one or two chief judges, because I've spoken with them, who are regretting the kinds of things they did when they were in office. And these are not people who retired long ago. They have retired recently and they become non-persons. So nobody's taking them seriously because of the kinds of things they did, which are not, again, publishable. And that really is the point here, that as these people, banalize the judicial system and corrupt it with these arrangements of barefaced capture, the consequences will be visited on them in their lifetimes.
You're talking of consequences. Is it how true is it that some of them, because of being refused visa to travel in some Western countries, could not access the standard of medical care they would have wished for themselves, seeing that the system in Nigeria is basically crumbling?
Well, I mean, you can see that. On the one hand, you can see that it's possible to now get. You no longer have to go to the West to get that. You can get it in the East. Many of them can go to Dubai, although now you no longer can get visas to Dubai if you're Nigerian. You can go to India. In parts of India, you can also get very good tertiary care. But that said, again, you notice that in the last 3 years, we've lost 3 justices of the Supreme Court, right? We've lost 3 justices of the Supreme Court, one from Ebonyi State, one from Delta State, another from Enugu State, in quick succession. That should tell you something about how terrible the situation has become. Whether or not it's as a result of Magnitsky measures, the fact of the matter is that something is fundamentally wrong with the well-being of justices of the Supreme Court.
Thank you very much, Professor Odinkalu. I wouldn't finish this interview without referring to the statement by the retiring Justice of the Supreme Court. I don't know how I forgot his name again. I have it in there.
Datijo, Muhammad Datijo?
Yes, that's the one that talked about the judiciary we have today is not the judiciary.
Yes.
Yes, Datijo, that's correct. He said something about the appointment of the justices of the Supreme Court being stopped before the election to stop people from certain parts of the country from being appointed. And there are several vacancies in the Supreme Court that have not been filled. So how are Nigerians taking that revelation, or does it not matter?
Again, I don't speak for Nigeria. everyone has got to speak for themselves in these matters. And unfortunately, a lot of people, because of the spectrum of interests involved, have frogs in their mouths over that particular matter, and few people want to address it. Particularly senior lawyers or senior politicians, few of them would want to engage with it. They find that their interests are so fundamentally intertwined on that particular issue, they're afraid. But you know, at least at the time he retired, Musa Dattijo Muhammad was the second senior most justice of the Supreme Court, and so what he says on this matter has got to be taken very seriously.
Thank you very much, Professor Chidi Odinkalu, for these. We spent almost an hour having this conversation, and I'm sure a lot of Nigerians will find some of the revelations here today very enlightening. The final question from me will be, what is the solution? In your opinion, what is the way forward for the Nigerian judiciary?
Well, I thought I covered that, you know, in the conversation we had about unbundling the office of the Chief Justice. And then also the things that we can be addressed through legal reform, limited as they may be. So you have a package through legal reform, a package through constitutional reform, but you've also, to make those work, fundamentally, we've got to create a cross-party, cross-hemispheric alliance of Nigerians on judicial transformation, on the transformation of judicial administration in Nigeria, because that's really where the key is. Unless we're able to create a political movement behind this, I think we are wasting our time. And seriously, right now, the biggest issue in the country is not what Tinubu does, it's what the judges do. It's not what INEC does, it's what the judges do. It's not what the political parties do, it is what the judges do. Unless every one of us recognizes that and keeps on the issue on the backs of the judges, we are wasting time. And that is why all of the assumptions we had about judicial independence have collapsed. Absolutely, all of them. And so the assumptions we lived by about how to respect judges and how to treat judges have collapsed. We have to treat judges in Nigeria now as grubby politicians. And until we understand that and treat them at that level, we will not realize how seriously the situation has become.
Once again, thank you very much, Professor Chidi Odinkalu, for being with us tonight. It's been a pleasure.
Thanks a lot, Dan.